What's new at the Appellate Division? Stay tuned for this month's Legal Scoop. Let's take a look at Wallace v. New York City School Support Services, Inc., which was a recent decision from March of this year dealing with the issue of a mental stress claim where you're only claiming mental stress. So let's have a refresher of the legal standard. With a mental injury claim where you're not claiming any physical injuries, the old standard used to be that you had to prove that you sustained stress greater than that of a similarly situated employee. Now that's changed, but not retroactively, as of June 4th of 2025, where they just have to demonstrate that they sustained extraordinary stress, and that's limited to acute stress disorder, PTSD, and major depressive disorder. But in this case, the standard that applied was this employee's stress greater than everyone else's stress in that same type of employment? The facts of this case were that the claimant was working as a custodian, and the facility he was working as was being converted into a migrant asylum building. And he claimed that during that conversion, he was exposed to asbestos, which stressed him out, or at least was concerned of being exposed to asbestos, and that the sanitation got worse once the migrants moved into this asylum facility, and that there were concerns of crime. But what's really interesting about this case is that the employer witness was able to refute the claimant's allegations. Basically, the claimant alleged that he was stressed about asbestos because he claimed to not have PPE. Well, the employer witness was able to prove that he did have access to PPE. The claimant alleged that there were all these sanitation issues when the migrants moved into this asylum facility. However, there was only a 5-day period where the claimant continued to work and the migrants were at the asylum facility. He claimed it was much longer than that, but that was refuted. And then other than that, he was also shown to be just not a good person, for lack of a better word. And they were able to establish that on the record by producing text messages that he sent to his supervisor. So what did the court hold? Well, applying the old standard of considering the claimant with respect to similarly situated workers, they found no stress greater than anyone else. But also what they really relied on here was that the claimant was not credible and didn't credibly establish the facts of his claim. So it's really, while that standard applied, it was actually even simpler to that. Claimant bears the burden of proving that an accident occurred, especially when it's on witness. And in this case, the claimant bears the burden of proving that what he's alleging caused him stress occurred, and he didn't do it because the employer witness was more credible and the claimant proved to be decidedly incredible. What does this tell us? Mental injury claim or not, which can be a little bit scary, developing your cases so that you can have a good record and potentially attack the credibility of the claim will win the day more often than not.